All right, welcome to today's presentation. Are you going to hit record, Connor?
It is already recording.
All right.
Good morning, everybody. How's it all going? We are talking today about cars, pets, art, boats, and guns, estate planning for specialty assets. We have clients come to us all the time concerned about how to give away these assets, how to make sure they're in trust. Jim, do you have any good stories for us about personal assets?
Well, I had a client years ago who's since passed away, and this is all public knowledge. He was the #1 collector in the world of single-shot British military pistols. So just get your head around that one. Single-shot British military pistol. Basically, it was muzzle-loaded firearm, typically with a flintlock or a cap lock. But this was, I mean, there are collectors out there. It's essentially, from 1750 to 1850. And I know, that was a collection. So people have these collections. Some of our clients have very valuable art. I live in Sacramento. Wayne Thiebaud is a very famous artist. He's turning 100 years old this year. And I was looking online. One of his paintings from about 5 years ago is $3 million. So some of our clients do collect art over the years, and sometimes it really appreciates, and they need to know how to handle it. Boats and planes and all these things that are kind of oddball assets. What do you do with them? One thing we didn't list there is wine, by the way, Connor. And that's a perishable asset. And so if you have an extensive wine collection, that's something that you will need to address in your estate plan, because a lot of people believe there's a lot of value, for example, with a wine collection. There is, if it's properly stored. So, some of these, and the same is true with guns and boats and, to an extent, art. So why don't you get started, Connor?
Yep. So everything we talk about today is totally for educational purposes only. It's not legal advice. And the reason why it's not legal advice is because one part of legal advice is we have to look at your unique situation. We have to assess what your particular needs are and then couple it with the rules. And when we don't know anything about you, we can't give that advice. So everything we talk about is purely educational only. Cunningham Legal, or we're going to allow for questions and answers as we go through this presentation today. You'll see the Q&A box. If you take you take your cursor, you can see Q&A and you can see chat. If you have a question, click on the Q&A box, type in your question, and we will answer those as we go through. We will also allow for some Q&A questions after today's presentation. Today's presentation is going to be, I would say, about 45 minutes long. And as I said earlier, it is being recorded. So if you happen to want to see it again, or you want to pass it to somebody you will be able to do so. All right, so Cunningham Legal, we have 7 different attorneys, offices in both Northern California and Southern California. Jim is primarily up north. I am down south. I work in Pasadena, but yesterday I was in Woodland Hills. Last week I was in Huntington Beach. So COVID brings these interesting times. Also, we do Zoom appointments. I think most of our clients are still meeting via Zoom for the initial consultation. Jim has been practicing since 1994. I believe that's correct.
Yep. That's a long time ago. I mean, it seems like yesterday, but it's a long time ago.
Yeah, quite some time. I think, Jim, what I'm experiencing is that a lot of clients think they did their estate plan with your father because they look at you and say, "No way, I did my estate plan back in 1996." So congratulations on
that one. When I first started practicing, I had clients, they said, I started practicing estate planning law at age 25. And I had this one client early on, he says, "I have socks older than you."
Yeah.
So, yeah, what are you going to do?
Stories too. Let's see. So Jim wrote the book, Savvy Estate Planning. That's how a lot of people find us, is from that book. It's on Amazon.com. And it's meant for people looking to set up an estate plan for the first time, but don't know where to begin. So going into our process today, if you have any questions, you can call us. Our clients, they can continue to call us for life, and we help them. We don't really charge by the hour for estate planning. We do flat fees, and we try to help our clients stay in the loop. So if they have questions, we do 15-minute phone calls. If we know it's going to be more than that, then we do an appointment. But we really want our clients to feel like they can depend on us. Going on, if you have a question today, if something arises, something that piques your interest, just call this number right here, the 866-988-3956 or the 530-269-1515.
Yeah, and a lot of the answers to questions so that you guys are going to have, it's like, well, it depends, and it's couched in this and couched in that, and it really does take a kind of a dialogue to get to where, as lawyers, we feel comfortable giving you appropriate advice. So really, it's kind of a comfort level on our part because we don't know everything that's in your head and in your heart, and it's, sometimes it requires an elicitation of that information in order to answer your question. So if somebody says, I have a question about this, we might say, okay, well, let me ask you these 4 questions. Okay, then we come back. So that's what the 15 minutes is for. And really, it's kind of a low commitment on both of our parts. And a lot of our clients, that after 15 minutes, they're done. Other people are like, oh my gosh, I didn't realize all this was going on. All these taxes that are going to get paid, all this problem for my family. Thank you so much, Connor, for helping me sort this out. So that's what the 15 minutes is for.
Yeah. So my name, Connor Clemens. You can call this number to book a consultation with me or to do a 15-minute phone call with me. My background's taxation, but today we're going to talk about personal property. So let's begin with a quick reminder. When you set up a trust, and many of you have seen this before, many of you have been to our previous webinars or might have recently set up their estate plan. A trust is not just a set of papers. A trust, you have to fund. You have to put your assets in the trust. So the big one is going to be real estate. You have to make sure that your real estate is deeded to your trust. Bank accounts, brokerage accounts, same thing. But what about personal property? Does personal property have to become part of a trust? And if so, how do you make personal property part of a trust?
So what we're talking about here is stuff. So this is not your bank account, nothing with the title. This is not your car. This is not your house. It's not your investment account. It's things like your firearms collection or your pets or your wine collection or your some type of asset that does not have a title. Or, as we're going to discuss, some assets have a title, but some government agencies, I hate to say it, they don't care about you and they don't care about your family. They just want to move that paperwork quickly through. And that's where boats and aircraft and mobile homes come in. We're going to talk about that.
Yep, that's exactly it. So tangible personal property, chattel, as some people call it. We're getting into all of it. So really quick to start off, most personal property is going to be assigned to the trust via a personal property assignment. Now, these personal property assignments, they haven't always been used. When I see people who have trusts that are over 10 years old, definitely over 20 years old, they don't oftentimes have a personal property assignment. A couple of the attorneys that we purchased, their firms I'm talking about, they did not use a personal property assignment. So what does a personal property assignment look like? Well, here's one that I drew up for myself. So you can see, so I, Connor J. Clemens, transferred to my trust all of my right and my tangible personal property. You can see here my jewelry, my clothing, my household furniture, furnishings, everything you can think of, okay? All of my tangible personal goods. When I sign this document, they're all owned by my trust. So it's somewhat theoretical, I suppose, but if the court ever wanted to know, did I put those things in my trust? Once I sign this document, the answer is yes. And this is going to be kind of the blanket that goes around all these personal items. Now, this is how you get property into the trust. And it's not the only way, but it's a very simplistic way to get it in. How do you get property out of the trust?
Can I just say one thing? That this is the assignment of personal property is kind of like a bill of sale. So if you're going to buy 6 head of cattle at auction, there is a bill of sale, right? If you're going to buy an automobile, there's a bill of sale. If you're going to buy an aircraft, there's a bill of sale. A bill of sale is a transaction between 2 parties. And we don't use a bill of sale because it's really, you'd kind of be selling it to yourself if you had a trust. So it's not a sale, but it is an assignment, and it's not like a homework assignment. This term is a legal term of art, which means you are transferring property, your personal property, to your trust. So in this context, assignment means transfer. It doesn't mean like a homework assignment.
Okay, so we get 2 questions popping in. The first one I think is from Kevin, I want to say. And Kevin says, pour over will. This is not a pour over will. We're actually going to talk about a pour over will in the subsequent slides, but this is a little bit different. This is just an assignment. You're not saying after my death, it becomes part of my trust. you're saying right now, these things are part of my trust. And then Jim, do you see that other question there?
Yeah, KH asks, does it include digital assets? Say data is stored in encrypted disk drives. I would say if you own the data, yes. But sometimes you really need to pay attention to your end user license agreement when you subscribe to software. For example, your Facebook page, you do not own that. And a lot of people don't realize that. Facebook owns all that content. So when you agree to use Facebook, you're transferring the rights to those photos and all those other bundle of rights. So on the narrow case of data on a disk, yes, but I would say that data is going to be subject to a potential other universe of rights. And you may not have, so an assignment only transfers what you own to the trust. I can't assign Connor's precious metals, and I'm just looking at one of them there. I can't assign Connor's precious metals to my trust by an assignment. That would be a bill of sale between Connor and I. So it's limited to the bundle of rights that you already have.
That's exactly it. All right. So we get people that are more concerned about getting personal property out of the trust rather than in. So how does property get out of a trust? So, I mean, if you have a trust, let's pretend you have 2 kids, 3 kids, there's a good chance your trust says everything, once I die, my wife dies, it goes to my 2 kids or my 3 kids equally. Now, if that's the case, your personal effects, they can be made up of whatever, or they can be distributed, however, to make up that 1/2 or that 1/3, whatever it is you're trying to do. Your trustee is going to select who gets what. Now, our clients, they don't always want their trustee to select who gets what. They want to distribute personal effects, but they also want to do it in an easy way. They don't want to necessarily write out in the trust that my baby grand piano goes to my oldest daughter. I personally don't like writing it. I'm sure Jim's the same way, because people are more likely to change their minds when you name a beneficiary in the trust. Also, people are given legal rights once you name them a beneficiary in the trust. So if you have something that you want to leave to your niece or nephew that your kids might not value as much, there has to be a simpler way to do it, right? And so that's where we're going with this, which is the personal property memorandum. And what that is it's a form that our clients can fill out after they meet with us. So, like, for example, if you have an engagement ring that you want to leave to your granddaughter and you don't want to print that in the trust, you can write down my 1-carat engagement ring to granddaughter. And you can do it after you sign the trust. And if you change your mind a couple of years later, you can cross it off. So,
So here's the deal. As a general rule, never write on a legal document. It's a bad idea. We don't know who wrote on it. We don't know what you were trying to do. If you say, but if I initial it and do all this other stuff, no. As a general rule, don't write on your legal documents. However, there is one document that you can write on, which is the personal property memorandum, because for our current clients and the clients going back probably 10 years, we've added this functionality to the estate plan, which actually people really love, because what you can do is you can set up your estate plan and you can say, I've got a green screen here. Behind this green screen, I've got, 15 guitars, two of the 15. And my son's a musician. He says, hey, Dad, can you put in your estate plan that, if you die, I know this is kind of weird, but if you die, can I get those guitars? I was like, sure. So I write that in my personal property memorandum. I don't want to put that in my living trust. And you may think, well, how do they know it's my writing? How do they know? People know their parents' writing. I mean, in most cases, it's going to be their parents. And we find that those gifts, Connor, on trust administration, I don't know that those are ever challenged, because they see their parents' writing and they're like, oh, yeah, okay, and whatever. But as a general rule, do not write in your estate plan except in this area. I will say another thing about personal property. My father-in-law is 88. He's living in assisted living about a block and a half from our house. Unfortunately, we're currently under COVID rules, so he can't leave. He's, basically locked in there. When we visit him, we have to go outside and have the personal protective equipment. He's gone from having 3 or 4 garages full of cars. He had like 30 cars at one point. Now he lives in a room and he's got a chair and, you know, like a little plastic cup and a bent straw with water in it and just a few items of personal property, he's already given away everything basically. So what we find is as people age, if you live long enough, you're not going to have a whole lot of stuff. Okay. So if you think about people in your own life that have aged, many of these items of personal property, you actually won't own by the time you pass away. So this is another thing to think about when it comes to personal property. Many people, they want to give the personal, you know, for example, the wedding ring, Connor, that you mentioned, give your granddaughter the wedding ring. Well, the grandparent may want to see the granddaughter hopefully get married, right? And have that as the granddaughter's wedding ring. So can be a lot of joy in making these gifts during lifetime. But for those gifts that aren't made during your lifetime, that's kind of what we're talking about. So, and Connor,
Yeah,
talk about the memorandum.
giving away stuff late in life, I swear that's a human instinct. It seems like so many people do it. But for the stuff that you want to hold on to, this is a great place to do it. And Jim talked about not writing on your documents. This personal property memorandum is specifically referenced within our trust. This is the one place where you can possibly write on things. We give our clients a document that looks just like this. You know, we give them multiple pages because plenty of people have a lot of gifts to make. And it's just so flexible in case you change your mind. All right, we have another question coming in. Is memorandum for giving the property away while I'm alive or after I'm dead? So it's given away after you pass away, or it's distributed after you pass away. If you're worried about something like fraud, it's not a terrible idea to fill your successor trustee in that you have one of these and maybe give them a copy and say, hey, look, these gifts are genuine. If you see additional gifts here.
Yeah. And the other thing too, I mentioned the Wayne Thiebaud painting. If you have one of those, right, and it's worth $3 million, you probably don't want to put it in the personal property. So there's like this realistic, and a friend of mine bought it in 2009. I think he bought like a 1962 Ferrari California in pieces, right? Which is a hugely collectible car. He ended up putting it back together and selling it. That car actually had no title and no VIN number. So, use some common sense, right? If it's worth millions of dollars, you probably want to put it in writing in your trust and deal with the estate tax issues that go with it. But, you know, if you're leaving grandma's china, you know, that's typically not going to be high value.
People aren't going to hire an attorney to fight over it.
You'd be surprised.
Yeah, sure. All right, so we had that question earlier that said pour over will. Yeah. What happens if you don't have an assignment document? So back before 2010, I would say, and definitely before like the year 2000, the old-fashioned way of transferring personal property to a trust was via a pour over will. So there'd be a pour over will, and there still is a pour over will, and that would say, after I pass away, I leave everything outside my trust, which includes my personal property for a lot of folks, to my trust. Now that has changed. And the reason why is because, like you can see here, probate is triggered by $166,000 or $166,250. And there are a lot of people out there that have over $166,000 in their estate. Or of personal assets, personal property. Like if you have a bunch of cars, you're going to be over this. Now, more likely than having a bunch of personal property worth that amount, let's say that you have a bank account or a brokerage account that you just forget to put in your trust and it's worth $130,000. And suddenly your personal effects are outside your trust, your jewelry, your car, your pets, your artwork, all that stuff. It makes the value outside your trust quickly add up to $166,000. And so suddenly your kids are subject to probate, or your successor is subject to probate. That's the reason why we don't utilize that pour over will anymore. Just because it could put you in a position where the kids go to probate, or at least they have what's called a Hakestead petition, which is a court hearing. Jim, do you have anything to add on that?
Yeah, well, you still have a pour over will when you do an estate plan, but the more modern best practices are to use an assignment of personal property. And so that as to untitled property, right? Things that don't have a title, that's the mechanism by which you get those into the trust.
So if you find yourself in a position where you think you don't have that personal property assignment, you can call us and we'll talk it over with you. Maybe you do have it, you're just not sure. We'll figure it out. Someone says, why wouldn't my bank accounts be in my trust? Well, I mean, in theory, they should be in your trust. We tell people to put their bank accounts in trust all the time, but a lot of people just don't do it for whatever reason. because-
Or you change a banking relationship and they say, well, I'm going to need this and that, and you go, forget it. Just put it in my name. It's easier. Or sometimes you have property that this is actually pretty common, that you will receive a check after death for a certain amount of money. If it goes over that 166,000, let's say you're in the middle of a real estate transaction, and that money may be payable to you as an individual. So this actually does come up quite a bit, where there are assets greater than 166,000 that are outside of your trust.
So continuing through, let's go through some actual specific assets, and cars are going to be the big one, because I have people tell me all the time or ask me, do I need to title my car to the trust? So short answer is going to be no. And it's kind of like how Jim said earlier. He said the government doesn't totally care about you. I just don't think they have the time to process these cars to the trust.
Yep.
So you leave them in your name. And this is just going to be like your regular cars, not collectible cars, regular cars that are registered with the DMV. Register them to your name. Now, once you pass away, the successor, your successor trustee, they're the ones who are in charge. They're the ones that should take your death certificate to the DMV, not your beneficiary, the successor trustee, and take access to the car so they can be distributed to the beneficiaries. There's a 40-day waiting period between death and when that can happen, but eventually it does happen. Jim, should the successor trustee obtain insurance on the vehicle while it's part of the-
this is kind of tricky, because in California, you have to have a policy of insurance. Insurance companies don't insure things. I mean, they do insure things, but what they do is they insure people. So a person who's got 5 DUIs and 20 speeding tickets will never get insurance. A person who, I'm paraphrasing, a person who's got a clean driving record they insure, and they might be driving the same car, but they insure the person, not the car. The car is insured, but what they're looking at is the person. When a person passes away, it is very common for the successor trustee to say, look, I got mom's car. I got to wait 40 days. We got to drive it around. We got to do whatever. Make sure you check in with your auto insurance agent and make sure that whoever is driving that car is listed as an additional insured. That is very, very important, because one thing that trustees have is 100% unlimited personal liability. If a trustee negligently entrusts a car to another individual, that trustees, all of their personal assets are potentially subject to pay damages for the damage that the person who was driving the car commits. The other thing, we have a couple questions here. Does a bank account need to be in a trust if there is a payable on death beneficiary designated? Chris, that's a good question. A payable on death beneficiary, a bank account that has a payable on death beneficiary, what that means is when the person who owns the account dies, the payable on death beneficiary can show up at the bank with the death certificate and collect the money. That passes outside of probate. That passes outside of the control of the trustee. A complicating factor with a POD account. A POD account is legally treated differently and than an account that you own individually. For example, if you have a POD account and you have a stroke and go to a nursing home, and you have a POD account for $100,000 and a bank account in your name or your trust for $100,000, which account do you pull the money out of first? There's an order of liquidation. If you're the person in charge of the person who's had a stroke, you're 100% liable for liquidating the accounts in the wrong order. So it's in the statute, it's in the probate code. There is an order of liquidation. So
let me
POD is kind of it's a little bit of a hack and a workaround. Sometimes it works. Oftentimes it causes more problems than it solves.
Jim, let me chime in for this question. So our most frustrated clients are people who are locked out of their parents' POD accounts, because POD, that might work, or it probably will work once you pass away. But if your successor trustee needs access to those funds and you are incapacitated, which is the reason why you set up this trust in the first place, they will be locked out, because what triggers the POD is a death certificate, not incapacity. If the trustee comes in to manage those funds, they're going to say this is not a trust asset either until you pass away or not at all, because you named your kids as your successor. So
Yeah, it's possible you could come in with the durable power of attorney and deal with that account. But again, you're going to have this issue of order of liquidation. And I'm telling you guys, folks, people don't understand these rules. A lot of lawyers don't understand these rules, but certainly the individual people who are serving as or acting as trustee, because if you think about it, if there's one POD beneficiary in the account and you take money out of that account, but there's 3 beneficiaries on the living trust account, which one do you take out of, right? So there are rules on that. So Jay asks, as a trustee, am I responsible for appraisals on all such assets, jewelry, coins, art, guns? Yes. That's your job as trustee. You're to collect the assets, you're to inventory and value the assets, and then make appropriate distributions. So yes.
So we talked about regular cars, but there are also collector cars like antique cars that aren't necessarily registered with the DMV. And in this case, you should utilize a bill of sale to transfer the collector car to your trust.
Not the assignment?
The assignment does it in theory, but it's not a terrible idea to fill out that bill of sale.
Right.
So continuing on to coins, I have a lot of people that purchase coins, purchase stamps. Should those be titled to the name of my trust? Now, if you look at that personal property assignment that we started with, that personal property assignment says that precious metals are going to be part of your trust. So that should cover you here. Now, if you really are a huge coin collector, it probably is not the worst idea to purchase these assets under the name of your trust. I've had plenty of clients who do it, but it's not going to be something that really sends you to probate if you just have a modest coin collection, because these coins are personal property. Do you have anything to tack on here, Jim?
Well, yeah, I collected coins I don't know, is anyone here a coin collector? I don't know if you can raise your hand if we're, I suppose we could have taken a poll. Some coins are, even the little ones that aren't gold or silver, sometimes the little coins are worth a lot, and sometimes the big coins aren't, the larger ones aren't worth that much. So there are 2 aspects to coins. There is the bullion value or the melt value. And so that would be, like silverware or silver coins. If there is no numismatic value, and that's the term, numismatic value is essentially rarity or scarcity. So the rarer a coin is, you can look at 2 coins that look exactly the same, but one has a different mint mark where it was basically manufactured by the US government. That one could have a much higher value. So here's what I would recommend. If you are a coin collector, my mom happens to be a coin collector. It's something we did growing up. I did growing up with her. I would really recommend that you name a separate person who understands the value of the coin collection. Think about that. Let your trustee know. Typically, you're going to know your trustee pretty well, but the trustee should have an idea of that the coin collection has value beyond essentially a melt value. The other issue with that is having coins appraised. Sometimes it's better to just sell them after a person passes away. Having them appraised, sometimes the active appraisal is like 40% of the value of the coin. So if you have a lot of coins of small value, it may not make sense to do that. So I think it's something that if you do have a big coin collection, just, reach out to Connor, and you'll probably end up talking to me because I know more about it. And then you'll also want to make sure that you go through a reputable dealer. There really aren't that many coin dealers out there, and finding a reputable one. If you do sell it, do sell your coins. And we helped a client with that years ago, a local coin dealer here in the Sacramento region. I think it was $85,000 worth of coins. So they can be significant. Okay. It was a fairly large bullion coin collection. So
in case anyone is interested, we work pretty closely with an appraiser of fine art. She's been really helpful. She can appraise people who need to have their stamps appraised, or she can refer people who need to have their coins appraised. So if you have any questions about that, you can contact us.
Yeah, and also I would just say we're covering an upcoming webinar about talking about assisted living. This is one of the areas where elders get ripped off, frankly. So elders, these are obviously, you can walk away with a box of coins worth literally hundreds of thousands of dollars and literally carry it out of the house. So you need to, if you are caring for an elder or you're elderly and you might be kind of facing this in the not too distant future, really think long and hard about where the coins are kept. do you keep them in a safe deposit box? Maybe, but then you have an access issue if you're not able to go to the safe deposit box. Do you put them in a safe? Well, then, you go through all the machinations. And many people, quite frankly, start giving those away to their relatives or their loved ones before they pass away.
Okay. So continuing through, pets. And I know for some people, I say right down here, people like their pets more than their kids. But in our world, pets are closer to personal property than they are to humans.
Mhm.
And it's important to come up with a plan in case something happens to you for your pets to get taken care of. And that might be beyond just naming a trustee for your trust. You should potentially set up an emergency caregiver. That's the word that's actually used by a lot of these foundations. Do you know of a person who will be interested in adopting your pet after you pass away? We go back to that personal property memorandum. If you can identify somebody who's interested in keeping your pets, you can write that person's name there and write your pet's description there. Now, not or if you do make that distribution of your pet to somebody, it's probably a good idea to give them a cash gift as well, just because it costs money to maintain a pet. Not everybody we have as a client has another person in mind who can take care of their pets. And so there are various nonprofits throughout the country that act as sanctuaries for pets. They all require cash gifts. And it's funny because when Jim and I were going over this webinar earlier, Jim was telling me that he knew of a sanctuary that took $2,500 for a cat. And Jim, you were like surprised by that. In our Pasadena office, we have referred quite a few clients to the Best Friends Lifetime Sanctuary program, where if you pass away, they come, they take your animal, they have it live in their sanctuary, which is in southern Utah, and they try to adopt the pet out. And if they can, that's great. But if they can't, the pet continues to live in southern Utah. They want $40,000 per animal.
How much?
$40,000.
40?
Yes. That's
Not
the most
4.
No, 40,000. We have set up a lot of estate plans where people say,
Is that the Four Seasons Pet Sanctuary? What is that? That's crazy. $40,000. Wow.
Best Friends Southern Utah Sanctuary.
Wow.
We have done a dozen estate plans that utilize that. But a lot of them, to be fair, they'll say, oh, I want my pets to go to X person. But if X person says no, send them to Utah. Because, I mean, a lot of people, they have their whatever it is, $1 million, $2 million, $40,000 to protect their loved one. That's fine. So a lot of people, they care about their pets. If you want to have a discussion about that, we're here to help. There are other organizations. I mean, I had one person, I should say, she left her dog to the Best Friends in Southern Utah, but her cats, she's leaving somewhere else because she knows her dog needs that attention that her cats might not. So that's
yeah. So on this, a couple of other points. There is something called a pet trust that is authorized under California law. Basically, you give money to a person, and that person's supposed to care for the pet. The wrinkle on that is essentially the pet charities have standing, meaning they can file a lawsuit against the person that you leave the money to enforce it. And when we go through this with a lot of clients, they're like, oh, I don't want, some crazy charity suing my friend who's taking my cats and dogs. So we don't write a whole lot of pet trusts. We do for some, but it really kind of depends. And then the San Francisco SPCA, if you do have pets and you're really concerned about it, I mean, this is a real issue. San Francisco SPCA, I think, has the most robust developed process, which is, hey, I've got a cat and 3 dogs, and it's about $2,500 per animal. So you have to leave that money plus the dollar amount plus the animals, and then they place those animals. And so they've got locations, I believe several locations in San Francisco, but that's one that some of our clients look at. And, but pets are really important to, especially as people age, and the process of aging. Your kids are gone, and then you might lose a spouse, and then your grandkids, they get married, and then, pets may be kind of a big part of your life. And I remember being in court, and we have a webinar coming up tomorrow with retired Judge Glenn Reeser. I was in court in Ventura County when a matter was called a will matter. And the person in their will said, I have 10 animals. I want all my animals euthanized after I pass away. And the judge asked the attorney this, is this true? And the attorney said, yeah. And the executors, euthanized 5 of these animals. And there was this audible gasp in the courtroom. Like no one, these are all probate lawyers. I mean, I don't know that I could put that into somebody's estate plan. That's just kind of creepy, right? And sad. And so the Judge Reeser, he said, well, you know what? I'm going to order you to stop euthanizing the animals, which a judge has the power to do that. And that's something important to understand. I'm going to order you to stop euthanizing those animals. And those animals were adopted by the court staff, actually. So that was kind of a cool resolution to it. But, if you're thinking about euthanizing your pets, it's kind of creepy. I would give some money to some charities. I would think about that. So. But I've never heard any client. Connor, have you ever had a client say they want to euthanize their pets? I mean,
no. And if I did, I tell them to go home. I would tell them,
right.
That's not controversial. If you want to euthanize your pets,
I hear you.
All right. So we do have a question. Going back to the coins. In the case of a valuable coin collection, would the personal property assignment effectively put title of the collection under the trust? Yeah, valuable. I mean, I don't know what valuable is. Valuable means $1,000 or $100,000. I think you're fine. But if it's more than that, it's probably worth looking into titling or insuring those assets under the trust, I would say.
Well, yeah. And then you get into issues of, theft. I mean, if it's a really valuable collection, if you're getting into the tens of thousands, hundreds of thousands of dollars, some of our clients actually have companies. And one thing to understand is when you buy and sell coins, if it's over $10,000, you don't pay sales tax. So a lot of people will buy coins in $10,000 tranches, right? They'll say, oh, I got $9,000 worth of coins, but if I go over that, there's no sales tax because it's considered an investment.
Person said $100,000 at least. A lot of my clients who buy coins, when they buy their coin, I know it's like a process where you do the contract, and I've helped people with it.
Yeah.
They title it to their trust, and I know it hurts to do that. I don't think it's the end of the world because you have the personal property assignment, but maybe as you acquire more coins, you title them to your trust as opposed just to your name. All right.
And if you're going to buy physical gold, one thing I was told by a gold dealer is look at 9999, 4 nines fine, in like 1 ounce rounds. The reason is if it's 3 nines fine, there are places in the world that won't buy those. So you get about $50 less per coin when you go to sell them. But when you buy them, they're typically closer in price. So just a little FYI.
Okay. So how about boats? We're going to talk about 2 different types of boats, really vessels. So we have the small boats registered with the DMV. They're essentially the same as a car. Now you can title them to the trust. I found the form online to do that, but you don't have to do that. So boats, very similar to cars. Now, I have seen some senior citizens, especially ones who are attorneys who've had a trust like since the 70s or 80s, who have their vehicles registered to the trust, because I think back in the day, that was the thing you wanted to do, probably to avoid the probate. But it's funny, I also have a lot of police officers, or I've had a lot of police officers throughout the years who are my clients, and they ask that question, do I have to title my car? I say no. And they say, I run plates a lot of the time for old people, and it says their car is owned by the trust. And I'm thinking like, what is this guy doing? So basically, if you title anything like a boat or a car to the trust and a police officer runs your plates, they're going to see it's part of the trust, and they'll probably size you up a little bit differently. So keep that in mind as well. Now,
meaning more favorably if you have a trust, like, oh, you're a rich person.
I don't know. Yeah,
maybe it's interesting.
Sure, or maybe the opposite. So you're just rolling the dice there. Now, large vessels. So this is going to be just the 1% of boats, or fewer than 1%. These are registered with the Coast Guard. And I also found a form there to register your large vessel in the name of the trust. And that's probably a good idea to do so, because these large vessels are going to be worth a lot of money. Their rule, though, is all trustees and beneficiaries with an enforceable interest must be U.S. citizens. And that should be a full quote. So enforceable interest is, if you're married, it's going to be you, your spouse, The two of you have to be U.S. citizens, otherwise you're violating their rule. If your remainder beneficiaries, the people who take over after you die, are not U.S. citizens and your trustee's not, you're going to be violating their rule. So that's a little caveat. But if you have a big vessel, title it to the trust.
Well, unless you're using, I would say the caveat is if it's a commercial vessel, if you're a fisherman, which we get a lot of fishermen on the coast and women clients, you'll probably want to consider putting that into some like an LLC or some type of entity just for asset protection.
That's a good point, and that probably applies to the airplanes we're about to talk about as well. So airplanes registered with the U.S. Department of Transportation. You know, I've had a couple people that own airplanes and they rent them out, or I guess they really lease them out to companies that train pilots on them. And both of them, they have their plane in an LLC for an obvious reason, because it's risky to train people inside planes and to keep up with the FAA standards. But if you have a personal plane, you can title this to the trust with AC Form 8050. And I wrote out the requirements just so you can kind of see an example of what it's like to transfer these things to trust. They just want to see these. I mean, Jim, you're a pilot, you know what the aircraft bill of sale is and the registration.
Yeah, so I'm a third generation pilot, and my mother's father was a pilot. And then my mom was actually an air taxi pilot in Alaska. And then my dad started flying in the 1960s, and he said they would take off. And once they got everything set up, you know, their autopilot going, both he and his instructor would whip out cigarettes and start smoking, because it was the 60s. That's what you did. So fast forward to 2020. One concern is 85% of aircraft accidents are pilot error. And that's something to be mindful of. As a pilot, you know, we're human beings. We're not perfect. If you're a pilot, if you have an aircraft and you put that in your living trust, I think that is probably something to think about long and hard, because if it's in your living trust, it exposes all of the assets of your trust to a potential liability. If you own it individually or you own it in an entity, when I owned my aircraft, I owned it in an entity, then you may have a better case for liability protection if you have a bad day. That's what we say in flying. So if you have a bad day, like a crash ruins your day, that's a euphemism. It's actually supposed to be humorous. So that's what we call it. Something to think about, because you hear about people crashing airplanes all the time. Right. So it's something to think about, but that's something where we can talk one-on-one, whether it should be in an entity, whether it should be owned individually. The nice thing about it being in an entity is you can transfer the shares of the entity. And there is some potential for some sales tax advantage. So.
Yep. There you go. So there's a reason why when you apply for life insurance, I think they say, do you fly for fun? Do you skydive? And I think
you smoke. Do you fly? If you smoke and you fly, you're probably not going to get life insurance.
It's probably, yeah. So definitely LLCs are something to think about. All right. So firearms. Now Jim is kind of the expert on firearms. And when I say the expert on firearms, so we're members of Wealth Council. That's an attorney group of estate planners. And I get invitations from Wealth Council saying that James L. Cunningham Jr. is going to host a webinar for attorneys only on firearms. So he's kind of the authority when it comes to firearms. So Jim, why don't you take the lead on this one?
Yeah. So here's the bottom line. Firearms are regulated by the federal government and they're regulated by the state. And the Attorney General's office in California, if they had one wish that could instantly come true, they would wish that there were no more firearms in the state of California. And this is an open secret. They're not, and I know guns is a very hot political, button. It is in the Second Amendment, and the purpose of arming the citizens is not to protect yourself. This is in the Constitution. It's to protect you from the government, which sounds crazy. And I know as I say that, it sounds a little crazy, but when you look at the framers, and I did in law school, took a 1-year course on the US Constitution beyond constitutional law. So this was actually the debates. This was a real issue because there was no law enforcement. If you go roll back time to 1783, when the Constitution was being written and adopted, the first police force was in Boston in 1838. There were no cops, right? So this is what people don't, in our modern age, you call 911. There was no 911 back in, the 18th century. And government, when you look at the governments that were around in 1781, they were all autocratic governments that took firearms away from people. And we were the only, at that point, the only democracy, with maybe the exception of Switzerland. So that's the background on firearms. Kind of fast forward, now we have all these firearms that can do all this damage, and it's a political debate backwards and forwards. I'm not talking about political debate. I'm talking about, if you own a firearm or you're the trustee of an estate and there's a firearm involved, something you need to know is there are prohibited persons and there are non-prohibited persons. The state of California has a list of classes of people who are prohibited persons. The most common prohibited person is somebody who does not have a firearm safety certificate. What's a firearm safety certificate? You go to a firearms dealer, they do a quick quiz, they sign off, they give you the certificate. Okay, it's not like you have to go to community college for 8 weeks and get a firearm safety certificate. But bear in mind that it is unlawful to transfer a firearm to somebody who does not possess a safety certificate. What does transfer a firearm mean? Under California law, you're at the shooting range and you're shooting your .22 pistol and you hand it to your grandson. If he does not have a firearm safety certificate, you have just committed a felony. You've committed a felony involving a firearm, which now makes you a prohibited person. Now, does this happen in the real world? We don't see it happening in the real world, but really kind of a close reading of the law, that's what it is. So let's put this in the context of what are other prohibited persons. Another common prohibited person is somebody who has a safety certificate, but basically they're incompetent, right? They have a stroke, dementia, Alzheimer's, Parkinson's, and they're no longer mentally competent. Well, for many clients, maybe the husband is the firearms enthusiast, maybe even a retired law enforcement officer, which is another layer another layer on there. If the husband becomes incapacitated and the wife does not know how to safely handle firearms, that is a dangerous situation. So the husband and wife, when they do their estate planning, many of our clients will designate a special person in the durable power of attorney or a special person in the will in the case of when someone dies. Firearms, by the way, do not get transferred to your trust, right? That's really important because that would be a transfer to the other potential co-trustee, right? So, and when I say firearms, I'm also including ammunition. So firearms and ammunition are interchangeable for our purposes here. And so when dad becomes incapacitated, maybe he appoints his son as his firearms agent. What does the son do? Well, the son should probably take possession of those firearms, scoop them up, and then look at dad's assignment or talk to the family and figure out, what are we going to do with these firearms? There are two viable options. Destruction is not one of them, okay, because these are assets that have a value. One is sell the firearms and take the money. The second one is transfer the firearms to some family member, perhaps, right, or a friend. So it's nice if you can have this kind of setup, whether it's formal or informal. Frankly, it doesn't really matter. The point I'm trying to drive home is when you talk to a federal firearms licensee, they will tell you, yeah, about every couple of months, a little old lady comes in. She just scoops up her husband's guns, long guns, pistols, dumps them in the trunk, drives him down to the firearms dealer and says, what do I do now? Of course, they're loaded, right? Which is, that's another felony, right? Driving with a loaded firearm in your car. But the point is, safety is number one. And secondly, these can be fairly valuable assets. I do want to touch on one other issue, and this is a very important issue. Many of our clients can possess firearms that are not possessible, that cannot be possessed by normal people. Now, what I mean by this is we have many clients who are retired law enforcement. Retired law enforcement, so people can be prohibited persons, and there are firearms that are prohibited firearms. So you might have heard in the news these, assault style, put that in air quotes, assault style rifle with a 30-round magazine. Well, that may be unlawful for a non-law enforcement person to possess, but may be lawful for a law enforcement or retired law enforcement to possess. So when that law enforcement individual becomes incapacitated and then becomes a prohibited person, now it's a felony to possess some of these firearms. So you need a mechanism. So if you're a retired cop, name your cop friend as your successor or maybe your son or daughter who's now in law enforcement, name that person, right? Someone who's matched up to you in terms of your lawful ability to possess certain prohibited firearms, and make sure you have a process in place. And it can be as informal as naming them as an agent under a durable power of attorney and in your will. And that way you can get those firearms either sold or transferred to an individual who can possess them. So we have a question. So in the case of a valuable coin collection, okay, we took care of that. That was done. So that's the bottom line is go through the federal firearms licensee. That's the safest way to do it. Do not go to Nevada to deliver a firearm to a grandkid. That is a felony, and that's a really serious felony, crossing a state line to transfer a firearm. And that one, you will get in trouble if you get caught.
Okay, so that's very good, Jim. That's what, like I said, he's the authority on that. I'll shift gears now to mobile homes. We have some clients that live in mobile homes throughout California, and if the home was titled before 1973 or in 73, then it's probably registered with the DMV. And to be safe, I would just register that home with the name of the trust, because that home is going to be worth, a fair amount of money. Now, most of the homes that we see are registered after 1973, and so therefore they're registered with the California Department of Housing and Community Development. Now, there is a procedure to title those homes to the trust. And I know some of our attorneys, or maybe one of our attorneys, has taken on that with a client before, and it's extremely challenging. Just like
I'd rather get a shingles shot than do that.
Yeah. So I guess the hack here, as Jim would say, would be to name the trust as beneficiary on the home with the Department of Housing and Community Development, or POD on the home. So that is really it there. Not a lot to it. I'm going to continue through.
That's it. By the way, that's if you have a mobile home. Some people say, should I put that in the trust? You have to get a duplicate certificate of title. You have to get a property tax clearance certificate. You have to submit a stack of paper, and it takes 6 months. There's a single form that just says, when I die, this person gets the mobile home. That's the one we use. So in that sense, this goes back to the POD question. Should we be using POD? Well, yeah, you can name the trust as the POD, right? And that's how you get it in the trust after you die.
And POD works really well in the mobile home.
Right.
All right. So our final two, which is going to be jewelry. That's the first one. I get people talk about, whatever jewelry collection they have. This one, once you sign that personal property assignment, it's part of the trust. And if you have some type of crazy piece of jewelry and you have title, you can title it. I bought jewelry before. I never am able to title it. I just have a certificate from GIA saying how much or what it is. And so, yeah, you're going to be fine if that is what you have once you sign the personal property agreement or assignment. Our final piece of chattel, as I call it, is going to be art. And it's very similar. It can be assigned once you sign that personal property assignment. Art also, it can be titled or insured. And if you really have that grade of art, something really valuable, same thing. It doesn't hurt to title to the trust, but once you sign your personal property assignment, in theory, it's part of the trust. Go ahead, Jim.
Yeah. So just a question on the guns. It says, all of my sons are in the military. That's good, right? First of all, thank you for your family service. My daughter served in the Army. My father-in-law is a retired Chief Master Sergeant, which is an E9 in the United States Air Force. He's 88. I mentioned him earlier. He's very bossy. For those of you who know what a chief is, he's super bossy. Keeps those are the guys that keep the military humming. The military, there are certain exemptions, but Robin, if you happen to be a law enforcement officer, it is possible that just because you're military doesn't necessarily mean you can possess those. So law enforcement is different than military, treated separately in the United States. And so I would, again, just check with your FFL. If you're not a firearm, if you're not a retired law enforcement, as long as the kids have their firearm safety certificate. And again, the best way to do this, Robin, is if you said, I want to give this pistol to my son, and I'm not using it, and I know he's going to have fun with it. Please, yes, there are interfamily or intra-family exemptions. You are best off going through the federal firearms licensee, do the paperwork, get it done right. My nephew's now serving over in Europe, actually as a NATO posting. and he left some of his firearms in Oklahoma. He got stationed at Beale Air Force Base in California, but he had to leave some of his firearms outside of California. So different state laws, different federal laws. If you're a firearms enthusiast, you know what I'm talking about. But I would say, as a general rule, whenever it comes to a firearm, especially in California, always think about going through the FFL, the Federal Firearms Licensee, first. I think that's the best course of action.
Okay, very good. So what to do now? If you're not sure if you have a personal property assignment, call us. We'll help you figure it out. What's a clue for that? If your trust is older than 10 years, if your trust is definitely older than 20 years, yeah. And I mean, lacking a personal property assignment, that might not be, I guess, the end of the world, but it could be in a way. But I mean, that's just one symptom, we'll call it, of an old estate plan, is if you're missing that document, it's definitely a reason to have things reviewed. So make a phone call. We can help. Like I said earlier, no obligation consultation, 15 minutes. Call us, 866-988-3956. You can ask to speak with me, and we will figure out if you and your family are protected. So that is essentially it. We are going to allow for questions and answers. Jim, do you have anything?
Yeah, something we've got coming up for those of you who know what Proposition 13 is, right? Remember Proposition 13, your property taxes? It's a great benefit for many Californians who have owned property for a long time. Your property taxes are much lower in many instances than if you had acquired that property today. Something you need to know, it looks like Prop 15 is not going to pass. That is the one that would have reassessed commercial and industrial property. But Prop 19 looks like it's going to pass. And that's a real sneaky proposition. And let me tell you why. Prop 19 takes away the parent-to-child reassessment exclusion. Let me give you an example. My parents bought in 1974 a condo in Ventura that we moved into when I was 5 years old. They've had that condo for 45 years. They paid $24,000 for the condo. And when Prop 13 was passed, they were, you kind of chuckle, Connor, $24,000 for a condo. I know you're looking at a house. You're like, I can't believe this. They paid $24,000 for a condo. Their property taxes in 1975 were $250 a year. They've gone up 2% a year. So now they're about $500 a year. The condo's worth about $450,000. Now, if Connor, if you were to buy that condo, your property taxes would be $5,000 a year. They would go from $500 to $5,000 a year. Effective February 16th, when my parents pass away and give that property to me, that property gets reassessed. Current law, up until February 15th, if they were to give me that property or they were to pass away, I get their low Prop 13 taxes. So I inherit that $500 tax bill instead of the $5,000 tax bill. So if you own real estate and you're protected by Prop 13, this is going away. February 16th. You'll be getting an email from us. You'll be getting some updates from us on what to do, planning strategies. But there are things that you can do, and you got to get those done by about mid-January, because stuff's not getting recorded at the recorder's office for about 30 days. So pay attention. Prop 19, if you're a fan of Prop 13 and you want to keep that for your kids, you will definitely want to check in with us. And if you'd like to check in with us before we start our webinar, we're doing 1 hour consults, and that's for $500 on a flat rate. So we look at your property tax bill, we look at your estate plan, we have a conversation with you, figure out how important Prop 13 is to you, and then what sort of things you can do. Now, that $500 does not include the planning that goes with it. I mean, and some of the planning might be just give your kid the house. I mean, that might be it. I mean, and there are reasons why you might or might not want to do that. But there are other ways where you can transfer that property to your kids now, keep the income, right? And still have the use up your parent-to-child reassessment exclusion. So
Jim, is that webinar that we're talking about, is it going to be on Saturday?
We are so busy right now we have 19 things. I think so. Is that the Saturday at 10:01? I think that's it. I remember texting you last night but we've been super busy. Whenever there's a change in administration, we tend to get busy. Now it's this confluence of change in property tax and change in administration. By the way, if you have a net worth of greater than $3.5 million, you absolutely need to be looking at gifting before the end of the year. The purported President-elect Joe Biden, which is still, it's kind of a touchy topic depending on what, where you are in the political spectrum. But it looks like Joe Biden will be our next president. His platform is to raise death taxes, which means drop the estate exemption to $3.5 million. So if you have a $5 million estate, it's about a $600,000 estate tax bill. If you've got a $10 million estate, it's about a $2.5 million estate tax bill. And that's if the rates don't go up. Right now, you can leave $11.5 million tax-free. So there are a lot of people out there who are looking to save $3 million on death tax, but you got to do it by the end of the year. And so many lawyers, I've been talking to lawyers, some of them have stopped taking new matters because they're just full till the end of the year. So something to think about. And Denise said, hey, I came in late. Will you be sending out the presentation? This will be posted on our YouTube page in a couple of days.
Great. All right, everybody. Thanks for joining us. Keep an eye out for our upcoming Proposition 19 webinar. It should be really good. Otherwise, have a great afternoon.
All right. See you guys. Thanks for coming.